With less than a month to go before California holds its recall election for Governor Gavin Newsom, a prominent legal scholar has made the argument that this process is actually probably unconstitutional. What's the reason he says it's unconstitutional, and what's the legal background here? And is his argument very strong? All of that coming up on Legal Bytes. Hey everyone, welcome to Legal Bytes. I'm Alyte, I'm a lawyer, and on this channel we explain the law one bite at a time. So this recall election in California is really interesting because in California they have this mechanism for voters to be able to essentially oust a public elected official before their term is up. Normally across the United States, we think of three main ways that a public official will leave office. The first would be not getting reelected after the end of their most recent term. The second would be getting impeached and removed from office. And of course, then there's the option of an elected official resigning before their term is over. But in California, there's this unique ability that the voters actually have to shorten a public official's term. I'll get into the basics of how a California recall election works in just a minute. But for now, just understand that this is the voters' opportunity to remove an elected official rather than having to wait out the rest of their term for them to be not reelected. The process is entirely voter-driven, which is probably one reason why, in California's history, only one governor has ever been successfully recalled. That was Governor Gray Davis in 2003, who was total recalled and replaced by the governor. I'm sorry, I couldn't resist. Aside from Gray Davis, 3 senators and 2 members of the Assembly have also been successfully recalled in the entire history of California's legislature. So it's exceedingly rare for an elected official to get successfully recalled. However, it is possible. So even though this process has been around for a while, and even though a handful of elected officials have actually been successfully recalled, a constitutional law scholar says that there's one problem with this. It might be unconstitutional. Which is important because, if true, would potentially take away California voters' main way of removing an elected official before their term is up. Be sure to watch this video until the end so that you can tell us whether or not you think this might be unconstitutional. Let's dive in. So the legal scholar that's been arguing that the California recall is unconstitutional is none other than Erwin Chemerinsky. An important thing to note about Erwin Chemerinsky is that he's the dean of UC Berkeley School of Law. That's a really good law school. He also is a well-renowned constitutional law scholar. I mean, he literally wrote the book that I learned constitutional law from. So basically, all of that is to say that when it comes to constitutional law, he's someone that people tend to listen to. Now, another thing to note about Erwin Chemerinsky is that, politically speaking, he is known to also be a little bit to the left, and quite vocally so. So when we are talking about legal arguments by Erwin Chemerinsky that have some touch point with politics, generally speaking, we want to listen, but maybe have a little bit of skepticism because of the possibility of political bias. So to unpack this whole situation, we're going to first look at the California recall process, and then we're going to look at Chemerinsky's arguments about why they may be unconstitutional, and then maybe a counter argument, and then, of course, I'll leave it to you to decide what you think. So why does Erwin Chemerinsky argue that the California recall process is unconstitutional? To answer that, first let's get into that recall process. California's recall process actually starts with a petition. It's a grassroots campaign of voters that basically decide that they want to gather together and sign a document saying that they want an election to recall the governor. It's actually for just about any elected official in the state of California, but because we're talking about the governor here, that's what we'll specify it as. So once enough signatures have been gathered, an election date is set, and basically it comes down to 2 main questions on the ballot. The first question asks whether or not the governor should be recalled. In other words, should the governor be removed from office? And the second question asks, who should replace the governor? A voter submitting a ballot can answer either question number 1 or question number 2 or both. Now, if a simple majority of voters vote no on question number 1, then that's the end of the discussion and Governor Newsom gets to keep his job until the end of his term. But on the other hand, if a simple majority of voters, meaning more than 50%, vote yes on question number 1,
you're fired.
Then they take a look at the results for question number 2, and the replacement candidate that gets more votes than any other replacement candidate gets to take the position. Note that the winning replacement candidate does not need a simple majority of the votes, simply a plurality. In a political system where we typically have 2 candidates running for one political office, namely one Republican and one Democrat, that seems a little bit odd. However, that's what the process has been since 1913. So again, why does Erwin Chemerinsky say that this process is unconstitutional? Well, he says the constitutional flaw is in question number 2 of this process, the part where they pick a replacement candidate. You see, in California, the current sitting governor can't run as a replacement candidate for himself in his own recall election. But Chemerinsky says that that violates the one person, one vote rule. So, what is the one person, one vote rule? It's basically the idea that one person's vote should weigh just as much as any other person's vote anywhere in that same state. It comes from the Equal Protection Clause of the 14th Amendment, which basically says that no state can deny any person within its jurisdiction the equal protection of the laws. As a reminder, the 14th Amendment was one of 3 amendments to the United States Constitution that were ratified after the conclusion of the Civil War. They abolished slavery and basically made way for the Civil Rights Movement. Since that time, the 14th Amendment has protected individuals from things like discrimination on the basis of race, sex, gender, religion, and other classifications. So the idea of the one person, one vote rule comes from the Equal Protection Clause. And as it relates to voting, typically the one party, one vote rule has come up in the context of redistricting. Now, things like gerrymandering and redistricting might sound like dry, boring subjects, but in actuality, they have a huge impact on our entire political process. They can have a huge impact on the outcome of our elections, and in actuality, there have been instances in history in which boundaries have been drawn in ways that do violate the Equal Protection Clause, typically along the lines of race. As an example, the biggest case on this issue was Reynolds v. Sims, a case that went up to the Supreme Court in 1964. In that case, the plaintiff alleged some serious discrimination against Alabama voters that lived in counties that had recently experienced a population boom. You see, there were some counties that had grown disproportionately more than other counties in Alabama. And every 10 years, a census was taken to determine how many people lived in each county. And even though Alabama's constitution required the legislative representation to be figured out based on that population as it was gathered in each census, the last time those boundaries were drawn was in 1900. Note that this lawsuit was filed over 60 years later. So you basically had some counties in Alabama that over the previous 60 years had a population boom, and other counties that did not. But the number of representatives for each of those counties remained the same. This essentially means that in some counties you had a certain number of people per representative, and in other counties you had a much larger number of people per representative. Which, if you take it a step further, basically means that a voter in a more populous county had a diluted vote. The United States Supreme Court said that this was essentially the same thing as telling some voters that their vote was worth twice or 3 times or even up to 10 times as much as other voters. And ultimately, that meant that the right to vote that people had in these disfavored areas was not the same right to vote that the people had living in these favored areas. And according to the Supreme Court, weighting votes based entirely upon where a person lives within a jurisdiction violates the Equal Protection Clause. So that is an example of the one person, one vote rule. Why does Chemerinsky say that the California recall election also violates the one person, one vote rule? I'll get into why in just one second, but if you're enjoying this content so far and you haven't hit the like button already, what are you waiting for?
Come on, do it, do it!
So again, why does Erwin Chemerinsky say that this process is unconstitutional? Well, he points to the possibility that there could be more California voters who support keeping Governor Newsom in his position than there are voters who support the ultimate replacing candidate. Let me use some numbers to clarify here. Let's assume that a majority of voters voted to recall Governor Newsom. For question number 1, let's say that decision was made on the slimmest of margins. Let's say he lost 51% to 49%. That would mean 49% of California voters actually want him to continue serving as governor. Then say we get to question number 2 and the leading replacement candidate gets only 18% of the statewide vote. I say 18% because that is apparently where Larry Elder, the current leading replacement candidate, stands according to polling. Chemerinsky is looking at the potential 49% support for Governor Newsom and the 18% polling support for Larry Elder and saying that actually the person that most Californians want in that scenario is Governor Newsom. So he argues this violates the one-party, one-vote rule because people who wanted Newsom to stay aren't fairly represented because they can't vote for him in question number 2. Another way of stating Chemerinsky's argument is that he's basically saying that because Governor Newsom can't replace himself in his own recall election, the voters that ultimately want him have a diluted vote. But if I may play devil's advocate here, there are 2 main counterarguments that I can see. The first is that it seems that everything that's been written on the one-party, one-vote rule has basically been about redistricting and the concern over the weight of one voter's vote in terms of where they live within that jurisdiction. There hasn't been a case, at least that I've come across, where the issue at hand has anything to do with the eligibility of a candidate to run in a particular election. In other words, I personally haven't seen any case law addressing whether the eligibility or lack thereof of a person to run in a particular election violates the one-party, one-vote rule. Now, that on its own doesn't necessarily mean that Chemerinsky's argument would be rejected out of hand because novel legal arguments are brought into courthouses all the time. After all, that's how we get watershed decisions. However, if we're looking for support from existing law, it doesn't really seem that there's much there. The second counterargument is that the logic that Chemerinsky uses can really also be used on the flip side. Let's say Governor Newsom were allowed to be a potential replacement candidate in his own recall election. If that were the case, there is an argument that the voters of the actual majority voters would then be diluted. That's because if that were the case, then any sitting governor who is facing a recall election wouldn't actually have to get a simple majority in the first question. In other words, they wouldn't need more than 50% of California voters to vote no on their recall. If a simple majority of California voters decided they did not want Governor Newsom as their governor anymore, he could simply go to question number 2 and get a plurality. So there could be a scenario where, let's say, 80% of California voters vote yes on question number 1, and then 20% of voters vote to keep Governor Newsom, and then 20% of the voters in question number 2 say that they want to choose Governor Newsom as their replacement governor because that's the person that they want to keep in the first place. If we assume the runner-up candidate gets 18% as is currently projected, then there's a difference of 2% between Governor Newsom and the runner-up. In that situation, an argument could be made that actually 80% of the voters in California have had their votes diluted. So then not only would question number 1 become entirely irrelevant, but any governor facing a potential recall wouldn't need to even get a simple majority. All they would need is a plurality and they keep their job. So what do you think of those 2 arguments? Which one is stronger? Or can you think of an argument that is better than either one of these? Let us know in the comments below. Otherwise, I hope you found this interesting or at least informative, and if you did, we would love it if you'd hit the like button. It does help us with the YouTube algorithm gods.
Eat this!
And otherwise, if you enjoyed this video and you want to see more content like this, be sure to hit the subscribe button and the notification bell. That way you can find out when the next video is uploaded. See you in the next video.